Hi, my name is Kim Mutcherson, co-dean of Rutgers Law School in Camden, and this is The Power of Attorney. So we're here for another recording session with two people who are absolutely perfect for the topic that we want to talk about today, which is to get into a little bit about Ruth Bader Ginsburg, the notorious RBG, and her legacy, but also to talk about the amazing things that my two colleagues who are with us today have done. So welcome Professor Sally Goldfarb and welcome Professor Ann Friedman to The Power of Attorney. Thank you both so much for being here with us today.
Thank you.
Glad to be here.
So I'm going to start this podcast the way I have started pretty much every podcast that I've done for The Power of Attorney, which is I love to take a few minutes to talk to people about their origin stories. I'm a big, superhero and comic person. So I like to know where people come from and how they ended up in this particular role, right? Given that there are so many things that you could have done in life. You decided that you wanted to become a lawyer. So let me ask Anne if you'd be willing to start. What's your origin story? How is it that you came to be somebody who thought that law was where you wanted to spend your life and your career?
Well, I'm someone who started in law school in 1968. And that means that I was in college starting in 1964. And that was a time when women were not well represented in the legal profession or indeed in professions generally. And so the process for me was one of, during the course of college, realizing that I had options about participating in the world of work and in the world of professions in a much broader way than my mother had. And I'd been supported by my parents to believe that I could do whatever I wanted to do. But it wasn't the same as it is now, where people start thinking about careers, little girls start thinking about careers much earlier than in my generation. So it was during college that I studied political science, and I got into my senior year, and I decided between going into the field of education, which is what my mother was more involved with, or going into law, and my dad was a lawyer. And I used to say, I still say sometimes, that I decided to go to law school partly because I had a passion for law as a tool of social change, which was what was fermenting in the air in the late 60s, but also because I wanted more power than one person is usually entitled to have. And my perception from my dad and my mom was that being a lawyer gave one more say in the affairs of the world than being in education. And then, of course, I ended up being a law professor, so I managed to combine both.
I love that. That's a great origin story. I love that, and I especially love the idea of having more power than one person should have. And I think that that's true for a lot of us who go into law, just in the sense of wanting to be able to use your voice in a powerful way. So thank you for that, Anne. Sally, can I ask you to do the same thing? What's your origin story?
Well, when I was in college, I was choosing between a career as a journalist and a career in law. I ultimately decided to go to law school because I thought I would become an attorney for journalists or newspapers. It turned out when I got to law school, I completely changed my mind. And of course, many of our students do that as well and end up being inspired to do something different than what they planned when they entered law school. For me, the inspiration to work in the field of sex discrimination law came in two ways, one negative and one positive. The negative was that I had studied English literature as an undergraduate and sort of took for granted that a lot of the authors of the books I was reading were women. I had a lot of female professors and a lot of female classmates, and a lot of the books I was reading addressed issues that seemed important and relevant to me. I got to law school. At the time I attended law school, very few women in my class. Of course, more women than had been true 10, 15, or 20 years earlier, but still only about 25% of the students in my law school were women. I had no female professors. The cases, as far as I could tell, had little to do with the issues that I cared about, and I just felt that women were being overlooked and excluded. So that was the negative. And then the positive was that the second semester of my first year, I took an elective course with a professor named Catherine McKinnon, who's a well-known feminist legal scholar who was then at the beginning of her career. And she inspired me to think about issues of sex discrimination law in a creative and disciplined way. And that inspired my future career choices.
That's amazing. We'll probably talk about that more. So, one of the things that you both talked about was being in law school at a time when, as Anne suggested, that the options for women were much more narrow, and that you said, Anne, that you weren't even really sort of thinking about your career choices in that way until you were in college. And then Sally, you also said that when you were in law school, about 25% of your class was women. And one of the things that is talked about a lot in the context of RBG is that when she was at Harvard Law School, that she was one of 9 women in her class. You can sort of imagine what that experience was like over those 3 years. She was also a mother at that time, and she was married, ended up graduating from Columbia, and wasn't able to get a job, even though she graduated at the top of her class. So, as people who were in law school many years ago and had a very particular experience there, and then who are teaching in law school now and have for some time, I'd love to talk a little bit about what you've seen in terms of law school classrooms, in terms of law school faculty, in terms of the courses that are being offered, that shift from when you were in law school to where we are today, and of course, where you still think we need to go. Sally, can you start this one?
I think the overarching theme about progress toward gender equality in this country and in the world is that we've come so far, and yet there's so much further to go. And I think that general theme applies to law schools. Today, nationally and at Rutgers, we have equal or greater equal representation of women among students. We have, diversity in terms of female and male faculty members. And certainly the topics that are taught in the law school take into account gender issues in a way that was not true at all 20 years ago, 30 years ago, 40 years ago. But we still have a way to go. There are still many opportunities for us to improve across all measures of diversity and inclusion. Among other things, in the current climate, we're well aware that discrimination does not affect all women equally, that women who belong to different identifications and different groups have different experiences of discrimination, and all of those things need to be taken into account.
Absolutely. Thank you. And Anne, in particular, I would love to hear some of your experience of, being a woman in law school in the 60s, which on one hand, right, a time when there weren't that many women in law school, certainly not like we see today, but there was, amazing activism going on in the world around a range of different issues. And I wonder sort of how that played itself out in the law school building. And then again, that's question of sort of where we are now and where you think we still have to go.
So one of the things that was great about going to law school when I went to law school was that there were so many opportunities for change because things were so stuck in the past. And the ferment of the late 60s and early 70s and the civil rights movement and the anti-war movement and women's recognition that we were not being given an equal voice even in movements for social change, and being inspired by the example of the civil rights movement. I really was grateful that when I was in law school, we were able to be part of a national movement to start the first courses on sex discrimination law and to begin researching what the legal status of women was. And that was what connected me to Ruth Bader Ginsburg, because she was already a professor at Rutgers, and she had this awakening courtesy of her students who wanted a course in sex discrimination. And we had started a sex discrimination course at my law school that was originally student taught. And actually, we had students and women married to law students in the class together, researching different topics and teaching, with each of us found a law professor to supervise us. And then that sort of launched sex discrimination courses at that law school, and we began to reach out to people at other law schools, and we had several conferences, including one right after I graduated, where we brought together 100 women and a few men from around the country who were beginning to teach sex discrimination law, and we shared materials. And we also founded a national conference on women in the law that met for a decade or more, where people from all over the country came together. And I remember vividly one meeting that I went to where one of the women from a Southern law school looked around the room and said, "I didn't know where there were this many women lawyers in the world."
Wow.
And so I have a sense about the possibility that law schools and other social institutions can change. Because when we started, sex discrimination was not taken seriously as a field. And by now, it is well established as a field. And of course, Ruth Bader Ginsburg played a very important role in making that happen. So I agree wholeheartedly with Sally that we still have a long way to go. And one of the things that has surprised me as I've gone through my career is how many times we have to work through the same issues, and so that it's not as though we move forward in an even line of progress. It's rather that the people get afraid by the prospect of full equality. They get afraid about diversity and inclusion, that people fear change. And as much as people are excited by change and benefit by change, there's also a lot of anxiety and resistance. And there are also political forces who take advantage of people's fears and anxieties and try to cultivate them. And so it's, instead of settling certain issues and coming together on a consensus and then moving on to the next issue, we settle an issue and come to consensus, but there's a significant group of people who decide they're not happy with that and launch a counter movement. And so it takes an enormous amount of energy to continue to address those issues in their new form, or even recurrences of old forms. And that's one of the things that's been really striking to me. And what it tells me is that as lawyers and as citizens and human beings, it's extremely important for us to reach out and be based in communities and be connected with people. That I think when I went to law school, even though we believed in community organizing and working with the people about what people wanted, we weren't as attuned to the complexity of really making change together across a lot of different groups of people. And I think that's something we're still working on in law schools, in the law, and in the country, and probably in the world.
Absolutely. So I want to go backwards a little bit in order to go forwards, because one of the things that you sort of spoke about, Anne, and I think Sally was sort of getting at this too, about how different law schools were, was that there wasn't really this, the field of law of sex discrimination in the way that we think about it today, and particularly in a way I think that a lot of younger women and younger people think about sex discrimination. It seems like obviously this was always the case, right? That we were having these conversations and fighting these fights. And yet, as is true with the African American civil rights movement, there was a lot of strategy and work and focus that went into building a body of law that could be used to deal with gender discrimination and sex discrimination. And Ruth Bader Ginsburg was certainly at the core of so much of that work. So I want to spend some time now talking about, both of you obviously are people who are deeply steeped in sex discrimination law. Both of you have amazing backgrounds of doing critical work. And I want to talk about, with you, Anne, I want to talk about the Women's Law Project in Philadelphia. With Sally, I want to talk about your work with the National Organization for Women, Legal Defense Fund, and the Violence Against Women Act. But just as a sort of general background for people, can we talk a little bit about, where this body of sex discrimination law came from and how it got built? Because I think a lot of people don't recognize that some of those really important early cases were about discrimination against men, not necessarily discrimination against women. Sally, do you want to start this for us?
Well, you can go way back to the beginnings of this country, even before the origins of this country, and find legal issues involving questions of gender equality. So this year we're celebrating the 100th anniversary of ratification of the 19th Amendment, which prohibits government from denying the vote on the basis of sex. Many people don't know that during the colonial period and after the founding of this country, women could vote in the state of New Jersey. The vote was taken away from women by a constitutional convention in the early 1800s. And it was then, of course, many, many years before the vote was available for women. And even when the ratification of the 19th Amendment had occurred, the vote was not available for all women because, Jim Crow laws and racist violence ensured that few, if any, African American women could vote. Restrictive immigration policies ensured that Chinese American women couldn't vote. Legal rules prohibited Native American women from voting, and so on. So that, these efforts go back literally hundreds of years. 1848 was the year in which the first Women's Rights Convention was held in Seneca Falls, New York, where the radical notion that women should be allowed to vote was publicly aired. And the folks at that convention, who included Frederick Douglass, the great formerly enslaved writer and orator, they were worried that if they called for the vote for women, it would be so inconceivable and radical a claim that it would undermine the rest of their agenda. So the history of striving for gender equality at the most basic level goes back centuries. But I think modern sex discrimination law can be traced in part to federal legislation of the 1960s, such as the Equal Pay Act and the Federal Civil Rights Act of 1964. And then, of course, to the groundbreaking litigation by Ruth Bader Ginsburg in particular, which led the U.S. Supreme Court in the 1970s to begin invalidating government actions on the basis of sex discrimination.
And do you want to add anything to that? And then I'm going to ask Sally to talk, as I was saying, about some of those early cases, because again, I think people don't necessarily know that part of the strategy wasn't just saying, here are the ways you're discriminating against women. It was, here are the ways you're discriminating against men as well, and engaging in sex stereotyping. So, Anne, did you want to jump in terms of that history of building sex discrimination law in the U.S.?
Well, I actually was going to talk a little bit about the issue of why the early cases were about discrimination against men, although the first case to change the rules, Reed versus Reed, was a case about discrimination against a woman in administering a deceased child's estate. But in terms of moving toward a heightened scrutiny, the next cases were about men. And that was one of the brilliant things about Ruth Bader Ginsburg's thinking, because she always understood that gender stereotyping was an interconnected whole, and that the idea of the homemaker breadwinner organization of society as a foundational principle of how things had to be and should be ran through all of our sex-based laws. And so that meant that men who assumed caregiving roles were not treated equally, just as women who wanted, like Myra Bradwell back in the last century, to be an attorney was not allowed to be an attorney because of the idea that women should be in the home. So it was the recognition that these things were interconnected and that we couldn't, there was always a tendency to justify sex discrimination by the idea that of separate but equal, that women in the home were performing a really critical social function and men were out in the marketplace and in the world of politics and law. And these were two separate spheres, which really only ever applied to middle class and well-to-do white women and didn't apply to other groups of women. But nonetheless, that ideal was presented as if it were for the benefit of women, that it was acknowledging something distinctive and desirable about sexist difference that needed to be expressed in our legal structures and that was foundational to the society. So the recognition that just as women needed to be able to become attorneys or to have equal rights to be politicians and run for office or to vote, that men needed to be able to perform caregiving roles and be recognized and given government benefits when they did so.
Absolutely. So I want to again do a little bit of backtracking for folks who, maybe some of our students who are listening to this who haven't had con law yet, because one of the things that you said early on, and was that the strategy was to move to more heightened scrutiny. So can you explain for folks kind of in a nutshell what we were talking about when we talk about what kind of scrutiny the Supreme Court is using and why it's important?
So ordinarily, when somebody brings a lawsuit challenging a law, either a state law or federal law, the Supreme Court assumes that what the legislature or the executive did was a reasonable and good thing. So in order to get the courts to look more closely at the factual foundation of whatever the government did and to test whether or not it is in fact based on some kind of real evidence, The courts have developed this idea under the 14th Amendment in particular that in certain contexts, we should look more closely at laws that impose burdens on people. And before Reed versus Reed was decided in the early 1970s, sex discrimination was not one of the reasons that would lead the court to look more closely at the evidentiary basis of a law. And what Ruth Bader Ginsburg's strategy with the ACLU was in the litigation was to get gender classifications to be recognized as a category that had such likelihood of being based on stereotype thinking and had such damaging effects that when a law uses a gender classification or disparately impacts men or women on the basis of their gender, that those laws should be looked at more closely by the courts to see if there really is a evidentiary, a real basis in fact and logic, rather than simply old assumptions about what men should do and women should do. And that's what Ruth Bader Ginsburg's victory with the ACLU over that period of time was about, was getting the court to look at these kind of classifications based on gender with a skeptical eye, instead of assuming, as a matter of course, that that was a sensible way to organize our legal system.
Perfect. Thank you. Sally, I want to jump over to you for the sort of next set of discussions, which is, continuing to think about, as Anne laid out, we had Reed versus Reed, and then there was this sort of ongoing strategy. And one of the things that I think, again, sort of thinking about, younger people and particularly younger women, what are some of the kinds of things that women in particular, that the law said, you can't do this, right? Whether it was meant to be protective or wherever it was coming from. What are some of the many things that federal law was used to keep women sort of in their place?
Well, the idea that there are separate spheres for men and women goes back over 100 years in this country. And to some extent, some of those attitudes endure today. But certainly in the 1960s and 70s, when the law was first beginning to examine these issues, there was widespread agreement that certain professions or enterprises or activities were really appropriate for men and others for women. Women were expected to take the overwhelming responsibility for domestic labor. Some might say that that's still true today. Men, on the other hand, were seen as the only ones fitting for the worlds of politics, the world of the military, the world of corporate executive suites. I even remember as a child having a book that was handed down to me from my older siblings, so it was a bit older than my own childhood era. It was a book about what I want to be when I grow up. And you could open it from one side and it said, what I want to be for boys. And it would be, I want to be a doctor. I want to be an astronaut. And then if you flipped it over and opened it from the other side, it was what I want to be when I grow up for girls. And it was, I want to be a nurse. I want to be a teacher. I want to be a secretary. But most of all, I want to be a mommy.
Oh,
Now,
boy.
there's nothing wrong with any of those things. I have enormous respect for each of those pursuits. But the idea that those are the only pursuits that are suitable for females is obviously deeply troubling. So even in my own lifetime, I've seen an evolution in attitudes towards sex roles. Certainly the litigation that Ruth Bader Ginsburg pioneered in the 1970s took aim at, for example, a Social Security law that conferred benefits on widows whose husbands had died, but did not offer the same benefit to a widower whose wife had died and the wife had been providing financial support for the family. And she very, very intelligently saw that that was an issue that could appeal to an all-male Supreme Court and make them see that sex discrimination and sex role stereotyping hurts everyone. She had a very sympathetic client who was a widower whose wife had died in childbirth. He wanted to take time off to take care of his young child. And under the Social Security law as it existed at the time, he was not eligible, even though his wife had paid into the Social Security system in her job as a teacher. So it really nicely crystallized the way in which sex role stereotyping hurts men as well as women.
So I want to look at sort of the progression of sex discrimination work and advocacy and law, because I think one of the things that's really neat to watch is how the sort of sex stereotyping litigation also sort of moved us into LGBT equality as well. And I don't know, maybe I'll ask Anne to start with this one, because we probably at some points were thinking, certainly within the law, of sexual orientation discrimination being sort of distinct from sex discrimination, but we're seeing how those things come together now. So, Anne, could you explain sort of where the trajectory has been of sex discrimination law and how it's really come to intersect with civil rights law for LGBT folks?
So it's really hard, I think, for some people, particularly people who aren't part of the LGBTQ community, to realize that the fact that homosexual conduct was criminalized under sodomy laws meant that particularly being a gay man, was stigmatized as being a criminal, because the sexual activity associated with same-sex partnership or same-sex relationships was treated as a crime under many states' laws. So as sex discrimination law moved forward, the reason why discrimination based on people based on sexual orientation or the sex of their chosen partner can be understood as a sex discrimination issue is because when you treat someone differently based on who they love, who they choose to live with, how they choose to live their lives, you're discriminating based on the fact that if I'm a woman and I choose to be with a man, then I'm treated one way. And if I'm a woman and I choose to be with a woman, then I'm treated in a different way. So there's that formal connection between sex discrimination and sexual orientation. But there's also a connection in the fact that one of the ways that people perceive same-sex relationships as threatening is they undercut gender stereotypes. People used to say about two men who are partners or two women who are partners, well, which one of you is the man and which one of you is the woman?
I promise you, people still say that.
Exactly. And so there's this way in which what we've been talking about how women should be one way and men should be another way, and that's a core organizing principle of society, separate spheres that we've been talking about. When you have two men together or if you have two women together, that threatens that idea. It suggests that people's choices are about what they individually want to be and who they are and what's best for them, and not what gender you are. And so as sodomy laws were struck down, because of the increasing recognition by the Supreme Court of the constitutional right of privacy, which was extended to cover sexual activity between same-sex partners in the Lawrence v. Texas case, once the criminal laws were no longer in place, it became much easier to organize for equality without regard to sexual orientation.
Right. I'm going to switch gears a little bit here because I want to make sure that we have some conversation about what both of you did before you came to be law professors. So, one of the things that I love about so many of the people who I work with is that they are what I call academic activists. So, people who are great in the classroom and who are, doing their thing in the academy, but who also care deeply about and want to use their skills for work that is more sort of activist in terms of changing the law. And both of you came to law school and to the legal academy having already done some really terrific things in terms of being activists and how you use the law. So I want to start with you, Sally. And I referenced this a little bit earlier about your work with now LDF. So can you talk to the listeners here about what that work was that you were doing, and in particular about the work that you did on the Violence Against Women Act?
As I mentioned, when I was in law school, I was inspired to enter the field of sex discrimination law, and I was fortunate after a one-year clerkship to get a fellowship to work at the National Women's Law Center in Washington, D.C., where I began to work on issues of sex discrimination. I then went to work for the now Legal Defense and Education Fund, a nonprofit women's rights law firm in New York City. And I was heading up the Family Law Project, and I assumed that I would be working on issues involving divorce and child custody and child support, and all of that was certainly true, but I was amazed at the extent to which family violence came to the fore in the caseload. That was just an overwhelming issue that I confess I had not previously focused on. And as I became more immersed in those issues, I began to, reach out to other lawyers, and I was working on a national level on these issues. And in 1990, I got a phone call from a staff member in the Senate Judiciary Committee of the Congress. She was working under the supervision of the Senate Judiciary Committee chairman, who was Senator Joseph Biden at the time. And Senator Biden wanted to draft legislation to address issues of violence against women, both domestic violence, sexual violence, and other kinds of violence against women. And because I was working on these issues, and because I was a relatively rare creature, I was working on these issues in the civil law context. And of course, there were many people working on these issues in the criminal arena, but relatively few who were looking at them from a civil perspective. And so this staff member asked me if I would assist. I said yes, not knowing that that project would then consume the next 4 years of my life. So I then became very involved with helping to draft the Federal Violence Against Women Act, testifying on it before Congress, helping others prepare testimony, working behind the scenes on strategy as the bill made its way through the convoluted process of becoming a law. And when it was finally signed into law by President Clinton in 1994, I was one of the people who watched it being signed. I was on the South Lawn of the White House watching it being signed. And it has turned out to be a very significant piece of legislation. It provides enormous amount of funding for programs to combat and redress violence against women. And I think it has helped raise the profile of this issue. It's really helped people to understand that types of violence that in the past were ignored or trivialized or justified really are a very serious problem. Now, one of the most interesting components of the Violence Against Women Act was a provision that made it a federal civil rights violation to commit an act of violence based on gender. That provision was struck down by the United States Supreme Court in the case of United States versus Morrison in 2000. And that opinion by the Supreme Court, which was written by Chief Justice Rehnquist, has been widely criticized, and in my view, rightly criticized. But nevertheless, the result was that that provision of the Violence Against Women Act is no longer in place. Interestingly, though, it inspired a number of states to enact similar legislation. And there's even the possibility that if the political winds blow in the right direction, that provision might be rewritten in a way to survive a federal constitutional challenge, reintroduced, and perhaps enacted again.
That's great. So, I mean, I love so many things about that work, but just the legacy of it is really quite stunning. So thank you for that work. And then, Anne, I want to hear you talk about the Women's Law Project in Philadelphia and your role in creating this enormous resource that continues to do amazing work in our region and beyond.
So, like Sally's story, my involvement in the Women's Law Project partly had its foundation in work at the federal level in supporting the adoption of the Equal Rights Amendment and its being sent to the states for passage, which was something I was involved with when I was in law school. And so while the federal Equal Rights Amendment was under consideration, and of course it's now under consideration again because we have 38 states who've actually ratified it, so there's a possibility that it may still become part of the Constitution. But in any event, one of the rationales for the Equal Rights Amendment was that it would cause both the federal government and the states to look through their existing laws and get rid of outdated sex discriminatory provisions rather than having to litigate case by case. At the same time, there were a number of states, including both Pennsylvania and New Jersey, that had state equal rights amendments. So a group of women with whom I was in law school met for a while after law school and decided that we wanted to start a women's rights law firm in Pennsylvania so that we could litigate cases and advocate for changes in Pennsylvania state law, which would help the people in Pennsylvania, particularly women, families, and children, but also so that it would be a model for how change could happen nationally if the Equal Rights Amendment were to be adopted. So the Women's Law Project came to Philadelphia because of the state ERA in Pennsylvania. And we were able to get some funding to get started. And then it has continued since we founded it to be a leading advocacy group for women and children and men affected by sex discrimination issues. And one of the things the Women's Law Project does is it litigates issues about reproductive freedom. And the case of Planned Parenthood versus Casey was litigated by two lawyers from the Women's Law Project all the way to the Supreme Court. That was after my time there. I was at the Women's Law Project for only 3 years before I went to be a public defender and then went on to teach. But I'm really proud of being part of the group of people who got it started. And one of the things that was interesting was that as a women's law firm engaged in social change work and as a nonprofit, we worked with other organizations around the country who were similar. And that included working with Now LDEF, I think before you were there, Sally, with Ruth Bader Ginsburg and the Women's Law Project, and Now LDF had a project to go through the federal statutes and get rid of sex discriminatory provisions. And we actually succeeded in getting a lot of changes in federal law through that program.
I just love that. So, and what I love about the stories that both of you just told is that it sort of leads to the last piece of this puzzle that I want to talk about, which is the idea of legacy. So certainly one of the things that we've been talking about since Ruth Bader Ginsburg passed away is what does she leave behind? And we know that she leaves behind this, legacy of sex discrimination law, this body of law that we'll continue to use. We know that she's also been important in other areas of the law in terms of her time on the court, right? The wonderful dissent she wrote in the Shelby County case about voting rights. There's a lot that's there. And then just the example that she leaves as a woman in law who was enormously successful in a lot of ways, sort of personally and professionally. And that's a really great thing to think about. And for both of you as well. I mean, you're both leaving tremendous legacies. I think about the lawyers and the interns and the folks who go through the Women's Law Project and you go out into the world and do fantastic things. And I think of all the people, Sally, who are impacted by VAWA and the ways in which that allows them to also lead fuller and richer lives than they otherwise would have had. So two questions for both of you. The first one is, what do you see as a sort of kind of core piece of RBG's legacy? And as we sit here and imagine someone else in what feels like her seat, who is not going to be RBG in any significant sort of way, what does that mean for the work that RBG did and what follows from that? And then my second question is, what, to the extent that you can sort of think about what you want your legacy to be in terms of whether it's the work that you did when you were practicing law or the work that you're doing at the law school now, what do you want to leave behind? Let's see. Anne, do you want to start that?
Sure. So I think you're asking about what Ruth Bader Ginsburg's legacy is first. And I want to say two things about that. One of them is the sophistication of her thinking about the Constitution and about the law and the role of the judge, and the importance of sharing that understanding in her opinions, even when those are dissenting opinions. And an example to me is her dissenting opinion in Gonzalez versus Carhart, a Supreme Court decision about reproductive rights, in which the majority was upholding a law on the basis of a protective idea that women couldn't really face the facts about making the choice to end a pregnancy. And she wrote really powerfully about the ways in which this was carrying on the same tradition of thinking of women as fragile and unable to make decisions about their own lives. And so I really appreciate there's a way in which the breadth of the many different areas and her ability to see what linked them and how to articulate that in a way that would be persuasive. And the other piece of it is, in terms of her legacy, is that she stood so powerfully for her values in a public way, regardless of whether she was on the winning side or the losing side. And I think all of us have been empowered by having her example. And I think in the time of her passing, it's particularly important for us to recognize that we're all still here, and that we need to, the best way to carry on her legacy is to be the same kind of people who have that kind of clarity about our positions, our willingness to think things through, and then to speak out. And that's what I hope my legacy will be, that I will be someone who has, both in my own career and also in my work in the law school, held up for public awareness the role that an individual and that groups of people can play when we stand for what we believe in and we speak up about it and we reach out to other people so that we can move social change forward.
Excellent. Thank you. Sally?
Ruth Bader Ginsburg was unquestionably a pioneering lawyer and judge, and she had enormous influence in those roles. But it's also important to remember that she was a teacher and a mentor, and she had a very significant impact in those roles as well. So that combination of being in the world of legal practice and in the world of teaching and encouraging young lawyers and future lawyers to pursue their dreams is something that I very much admire, and I try to emulate, of course, in a much smaller way. I think that as we're thinking about, for example, the 100th anniversary of the 19th Amendment and the difficult and lengthy battle that it took to gain the vote for women, it's important to remember that the leaders of that movement, of course, were indispensable, but so were the masses of nameless, faceless individuals who fought for the extension of the vote. And today, it's easy to forget how large that movement was, how many people whose names and faces today are forgotten, but who made an enormous difference. And, I feel that as we look ahead to the future of gender equality law and gender equality more broadly, it's important to view this as a movement in which there's not only room for everyone to participate, but there's a need for everyone to participate. So for me as a teacher, my goal is to not necessarily, sway my students to enter one field of law or another, but rather to give them the tools they need to pursue whatever goals and interests are most important to them. And that's, I guess, the legacy that I'd like to leave, which is just helping the students discover their passions and build the skills that will enable them to achieve the kind of work that they want to do.
Excellent. Well, thank you both so much again for your time today, for the stories that you've told, the information that you've shared. This has been a really rich conversation, and I certainly appreciate it and hope that others will as well. So thank you again, and I will leave you to enjoy the beautiful weather we're having today.
Thank you. It was a pleasure.
Me too.
The Power of Attorney is produced by Rutgers Law School. With 2 locations, minutes from Philadelphia and New York City, Rutgers Law offers the prestige and reputation of a large, nationally known university with a personal small campus experience. Learn more by visiting law.rutgers.edu.